All right, Mr. Cruz, do you want to clarify your question and see if I understand what you're asking?
Yes, ma'am.
Go ahead.
Before our trial, I filed residual hearsay motions. The Honorable Court entered an order stating that I could not ask any witness anything about what Ms. Baker told them until, I believe you prefaced it on, depending on what Chris Melton's testimony was. You said you would make a ruling after, I'm paraphrasing, you would make a ruling once Chris Melton testified. You instructed me that in opening, I could not mention anything that Ms. Baker may have said to anyone. And as you know, in opening yesterday, I was held in contempt for making a statement that Chris Melton made that the Honorable Court, that Mr. Yalamachili asked for, and the Honorable Court granted, saying that I violated Rule 412 based on me stating that Mr. Melton stated she must have been with someone else when he was told that somebody else's DNA was found after he knew for 25 years somebody else's DNA was, or at least he was told DNA was present. Based on yesterday, I said, well, look, I need to be conservative. I don't want to offend the court in any way. I don't want the court to think I'm doing anything intentional when I'm not. So I assumed that Ahmad, don't speak on anything regarding Tara Baker's statements until the Honorable Court makes a ruling. However, Mr. Yalamachili just asked Ms. Lonstein, based on what Tara Baker told you, what is your impression of the relationship? And I looked at the Honorable Court to see if the Honorable Court was going to say anything. Nothing was said. So that's why I came to the bench to just get clarity. And the only thing I want to do, Your Honor, I just don't want to offend you. I don't want to offend you. Yesterday, I got held in contempt, and I didn't even realize that I was doing something that was improper. So I'm trying to make sure I'm walking on eggshells for Your Honor. I'm trying to make sure I do everything right for Your Honor. So I just want clarity that if that question is okay based on the court's order. That's the only thing I want clarity on. Can I ask witnesses based on what Ms. Baker told them, what is their impression of the relationship with Chris Melton and Ms. Baker?
All right, Mr. Cruz, you are mischaracterizing the court's order completely. Yesterday's moments were based on a ruling that the court made on January 21st with regard to the state's appropriate filing of a 412 motion. And we've said this, we've discussed this over and over again. And the court has noted over and over again that the defense did not file a 412 motion. The defense only acknowledged in open court to the state with regard to their motion that the only person that they would introduce or attempt to introduce evidence for with regard to any exception for 412 was Mr. Melton. And we've discussed over and over again the fact that should the defense wish to attempt to introduce evidence other than Mr. Melton, that a proper motion had to be filed. We've talked about that over and over again. Yesterday, I made a finding that you first attempted to circumnavigate that policy, that procedure, by insinuating certain things in your opening. The state made an objection. I sustained it. And I had a pretty lengthy discussion with counsel outside the presence of the jury, warning counsel not to do that. When you did it again, the state made an objection. I sent the jury out, and that's when I made a finding of contempt after allowing you certainly to explain yourself. And I found that that was a violation of the court's order with regard to 412. And so your characterization for the court about what you're allowed to say and what you're not allowed to say is not, does not comport with what happened yesterday. The motion that you filed, notice of intention to introduce residual hearsay testimony, is in relation to certain statements that you are asking the court to admit. They are pending. And they are pending because I made, and you appropriately said this, it will depend on how the evidence unfolds. And we will take up these motions again if necessary as the case proceeds. But there is nothing improper in the way that Mr. Yellowman-Chili asked that question. And it has nothing to do with 412. It doesn't have anything to do with my prohibition that I gave the defense. I think the insinuation that the court is being unfair and allowing one side to do something and the other side not to do something is absolutely mischaracterizing my order. And so I'm responding to your comments, Mr. Cruz. If you have an objection to the state's questions, you certainly may present it right now, and I will make a ruling.
This is the situation the defense is in. I am handcuffed. Being held in contempt is a very severe sanction against an attorney. It is very severe. So what I have to navigate is being respectful to the court, also following the law, but most importantly, following the court's orders. The state, they have no prohibitions on him. I can't argue consent. The court said, well, you can't say anything about consent in regards to the DNA. Mr. Yellowman-Chili, who got up yesterday and said, oh, Mr. Cruz is so disingenuous. This prosecution is disingenuous. This guy is innocent. The evidence will show he's clearly innocent. So, but I won't go there. But we have restrictions. We have restrictions on us that the state does not have. So what I have to do, because I've been held in contempt, is I have to make sure I don't do anything that'll surprise me like it did yesterday.
Okay,
so
Mr. Cruz, I would like to respond this way. Your characterization of being handcuffed, so you speak, is very unfortunate. And I think that is an unfortunate way to address the fact that the only reason that we're having this discussion is because you have not filed the appropriate motions for the court to take up. And the ruling that the court made about whether the defense can introduce a defense of consent and other things that you mentioned are because, and we have talked about this many times, that you have failed to file the proper motions. Because when you file the proper motions, the court will hear argument as to whether your motions are appropriate, as to whether the evidence you are seeking to admit is admissible. And if that is not done, then what you're seeking to admit is not allowed. And that is just the law. And so to characterize the court's allowing one party to do things and the other side being, in your words, handcuffed is not accurate. It is misleading. That is not why the court made a finding of contempt yesterday. I'm not going to go back over my finding, but suffice it to say, I think I was pretty thorough on the record twice about whether the defense was allowed to say certain things. The rulings that I have made that supported the court's comments yesterday are in the record. They are on the record. And Mr. Cruz, you are very well aware of the reasons that the court made those rulings. And so unless and until the defense files the proper motion, which would then provide the atmosphere for both sides to argue as to whether the evidence you're asking to admit is admissible, it is prohibited. And that is the law. And so I'm not going to argue with you about that. I think your characterization of what is allowed and is not allowed is mischaracterized. I can't think of another way to say it.
Your Honor, we gave you 5 cases that 412 did not apply to a defendant saying that to a rape allegation, he's raising the defense.
I'm not going to revisit that moment, Mr. Cruz. I've already made my ruling.
Yes, ma'am.
And so it is not appropriate to re-argue that you're right and the court is wrong. There is another venue for that.
Yes, ma'am.
I've made a ruling, and you certainly can take it up if necessary in another venue. But for now, I'm not going to revisit that ruling.
Yes,
I've made that ruling. And unless until you are filing the appropriate motions to be heard, and I've told you yesterday that if you do file those motions, even though they are not timely, I will consider them. But until then, my ruling does stand. And so I just need to ask you your objection right now so that I know that I've finally finished making whatever ruling it is with regard to what Mr. Yalamanchili was talking about.
So I didn't have an objection. That's why I approached the
Okay.
bench. The question that I was asking, because
Yes.
maybe I'm misinterpreting what the Honorable Court instructed me to do and to stay away from. I just want to know, because what I'm scared of is I ask the question, Mr. Yalamanchili hops up, Judge, he's done this on purpose, hold him in contempt again. I'm just asking, Judge, is it okay? And we could have kept it at the bench. Is it okay? I just want to be clear. Is it okay if I ask witnesses the exact question? Based on what Ms. Baker told you and what she discussed in her relationship, what was your impression about Ms. Baker's and Chris Melton's relationship? Is that an okay question for me to ask?
Yes, it is, sir.
Yes,
That's what the state just asked.
Yes, ma'am.
Yes, sir.
Thank you, Your Honor.
And that was one of the moments with regard to that particular witness, Mr. Melton, that was basically properly noticed by the defense to the state, because we had a hearing where we had that discussion. And so even though that notice was an oral notice as opposed to a written motion, we had that discussion in court. My ruling on the 21st was based on that acknowledgement by the defense to the state in proper form. So yes, sir. The answer to your question is yes. Mr. Yalamanchili, did you want to respond at all? I've been talking with Mr. Cruz. You're the other party. If you'd like to make a response, you may. And then Mr. Cruz, you'll have the last word. Go ahead.
Thank you, Your Honor. As the court said, the issue Mr. Cruz actually raised at the bench where the discussion started had nothing to do with 412. The court's already said we're not revisiting the long discussions. The court's reviewed all the cases, made its ruling in accordance with the laws of the state of Georgia. I just want to, I guess, establish for purposes of the record that Mr. Cruz filed a notice of intent to introduce residual hearsay statements. So asking to actually elicit hearsay from witnesses. The court withheld its ruling. I do want to say that at least, and I don't have a transcript in front of me, but I think Mr. Cruz has misconstrued the court's order as it related to that, which was we are going to hold rulings on this notice until such time as there has been testimony from the witness and some of the predicate requirements may be met about truthfulness. And then the court, obviously, it will be in your discretion even to admit or deny the introduction of those statements. But I just want to establish for the record, the state did not elicit any hearsay statement regarding Ms. Baker saying what it was about the relationship. We established foundation that this is a person who had discussions with Ms. Baker about her relationship, and we laid a foundation that they had a close and trusted friendship, and then just asked her about her impressions of their relationship. So I just want to make that clear for the record.
Right. And I think that's an important distinction. So, Mr. Cruz, with regard to your question, let's go back to your question. Your question about eliciting information about the witness's impression of any status of relationship between Ms. Baker and Mr. Melton is certainly permissible. The state just asked it. The defense can ask the same thing. What neither party can do right now is elicit hearsay testimony. And let me just rephrase so we're on the same page. Because sometimes these things can get very technical, and I want to make sure that all parties are on the same page, and that is this. For example, asking a question of this witness or any witness, based on what Ms. Baker told you, do you have an opinion on X, Y, and Z? At the moment, that's not a permissible question, right? Because it is eliciting hearsay. The way that Mr. Yalamanchili has just phrased what he asked this witness is permissible based on your relation. I'm not going to tell you how to make your question, but something to the effect of how he just phrased it, based on your relationship with a certain person, the hours you spent together, the things that you discussed. Do you have an impression of the relationship? That kind of a question is permissible. The state just asked something like that. The defense has every right to respond and ask the same kind of a question. But eliciting actual hearsay testimony is not permissible at this point. Does that make sense?
I agree with the Honorable Court's ruling. I just wanted to make sure that I'm within the proper parameters, and just let Honorable Court know, exactly where we're coming from as the defense. It's new ground when a prosecutor stands up and says, Judge, this attorney has said something and he should be held in contempt, and he's held in contempt. When the statement, again, that Chris Melton says she must have been with someone else when confronted with DNA has nothing to do with 412. I am very familiar with the 412 statute. That has nothing to do with 412.
We're not.
Go ahead, John.
I'm sorry, Judge, just because Mr. Cruz has directly referenced statements that I've made, I would just like to say I've never in my career as a prosecutor or a defense attorney, thankfully, until this trial, been put in a situation where I had to make that request, but we were put in a situation where we had to make that request.
For both parties, I'm not going to relitigate the moment where I've held you in contempt, Mr. Cruz.
Yes, ma'am.
I am going to tell you that the comments that you have made, in my opinion, are mischaracterizing what happened yesterday. I'm not relitigating that moment.
Yes, ma'am.
I'm going to ask that all parties move on.
Yes, ma'am.
It is 5 after 12. I'm instructing both parties not to violate my ruling on 412. If there is a motion filed, even though it is untimely, I will consider it. But other than that, we need to move along. So is there anything else, Mr. Cruz, you would like to ask the court?
No, ma'am.
All right. Thank you.
Your Honor.
Yes.
Just to let you know, I am walking on eggshells. So if I have concerns about something, I'll just ask to approach the bench. It doesn't even have to be on the record. I just want to make sure I don't violate anything that the Honorable Court puts in place.
Well, Mr. Cruz, I'm sorry to hear that. I don't know that walking on eggshells is a fair representation of what happened yesterday. I think the appropriate response should be to review the court's rulings and just recognize what they are and not violate them.
Yes, ma'am.
All right. Thank you. If you'll bring the jury up, please. Thank you.
Stand up for the jury.
Thank you. Everyone may be seated. Mr. Yamachili, you have the floor.